So if you could just, I guess I'll take a wee step back to explain to everyone who's present today. This session has come out of questions that we tend to get from our clients, from tenants, and from team members ourselves. It's come up when we've done conversations with Sal, it's come up when we've done adjudication training. People can get a little bit confused between the ADR process offered by the schemes and the First-tier Tribunal. So what we wanted to do was to get Sara down here, we'll get all these questions out. And what we'll do is we'll run through the questions that we've been sent ahead of time, and then I'll open the floor for anything that's there. Sara and I, we've got pretty much a free diary for the next couple of hours. So any questions, honestly, please use the opportunity. We'll get through as many as we can. Any questions that we can't get around to, or if you need to go, if you pop them into the chat box, what I'll do is I'll collate them all and I'll liaise with Sara to get them answered, and then we'll send them out to you guys by email in the next couple of days, if that's okay. So to kick off, Sara, I guess the most obvious question would be, what's the difference between adjudication and the First-tier Tribunal?
Okay. So when I'm acting as an adjudicator for safe deposits, I have very strict guidelines that I have to adhere to. In particular, I have to make sure that I don't award more than the deposit that's protected. That's one of the main differences between an adjudicator working for safe deposits. The ceiling is the amount of the deposit that's protected at safe deposits. We can't award any more than that. You can make a claim in excess of the deposit in as much as you can make a claim for all sorts of things, and the adjudicator will carry on awarding up to that ceiling, but cannot go beyond it. If you make a claim against the deposit at the First-tier Tribunal, a claim under civil proceedings for damages, basically, perhaps because the tenant has carried out various works at the property, or there are various issues that arise at the end of the tenancy, whether that's something like damage to carpets. I was looking at a case the other day where the tenant had thrown bleach across all the carpets at the end of the tenancy. Then the First-tier Tribunal can base their decision on an award for compensation, basically. Taking into account similar principles that we do at safe deposits, you'll all be aware of fair wear and tear and betterment, but they can award for more than the deposit. In fact, very frequently, the First-tier Tribunal will look at whether or not a deposit award has been made by a tenancy deposit scheme. You can submit an adjudicator's report as part of your evidence to the First-tier Tribunal, but then they'll just take on an award after that based on what they think is just and proportionate in the circumstances of the case. So that's one of the main differences, really. The restrictions that are based on adjudication with safe deposits, and really, if you have a very difficult or a very expensive case at the end, then you can claim the deposit first and move on to the First-tier Tribunal, or make applications at the same time, because of course, you know, you have to take in mind that time barring applies too.
Yep. So this is something we get asked quite a lot is, you know, if it's a claim in excess of the deposit, should they use adjudication first? Should they go to the First-tier Tribunal first? And, you know, if they go through ADR, what do you guys do as FTT members do with that information and do with that evidence? It is something that genuinely concerns a lot of letting agents in particular out there, particularly when you see, I guess we've all seen instances where, you know, there might be thousands of pounds of rent arrears, and like you say, the bleach on the floor, and before you know it, the deposit is nowhere near enough. So what advice would you give to someone coming in with a case like that, how to approach it?
I think you have to bear in mind, first of all, that a tenancy deposit scheme adjudicator will settle claims at their own discretion in terms of applying an order of looking at the claims. So if you make a claim for rent arrears to a deposit adjudicator, they may look at that first, or they may look at cleaning, damage, etc., whatever your whole list of claims is. But again, they will only award up to that ceiling. You can save your claim for rent arrears for the First-tier Tribunal and handle that separately. And indeed, at the First-tier Tribunal, most of the cases that are currently being submitted are, not surprisingly in the current times, on rent arrears. So you may wish to save your whole claim for rent arrears to the First-tier Tribunal and deal with more minor claims at adjudication, bearing in mind what you feel the main thrust of your claim is. It's difficult to say what's right and what's wrong, because it's going to depend on your strategy as an agent, what you want to achieve for your client, and how you see the claim going based on the evidence that you've got in front of you. But quite frequently, you can leave the smaller minor claims to the tenancy deposit scheme and leave your larger claims perhaps to the first-tier tribunal. It's difficult because sometimes you've got to run the claims together. You've got to make a submission to safe deposits when the tenancy ends, and you've got a time limit to do that. And you've also got a time limit at the first-tier tribunal. You've got to try and make your claim within 3 months at the end of the tenancy. So, you know, you may need to consider making a submission of each application at the same time. It's taking about 4 months to get a civil proceedings claim through the tribunal at the moment. And I think, Paula, it's probably taking about 3 months to get a claim through safe deposits. We always say, you know, when you put a marker down for adjudication, then you have to be aware that it's not a quick and easy solution. And for that reason, I'm sure you're all aware, we have our early resolution process at Safe Deposits.
Well, that's what I was going to touch on there. So if anyone's gone through adjudication, you'll know yourself, you're looking at between 8 and 12 weeks to reach some sort of conclusion on it. So we've introduced, as of the 1st of April, this mandatory, I guess, self-resolution stage. So the legislation the deposit schemes work under says that we need to be satisfied that all attempts to resolve a case have been made before it comes to adjudication. And up until 1st of April, we hadn't really pushed back on that, and we just accepted them all as they came. But what we identified was that there was a lot of cases that really didn't need to come through us, that could be easily resolved. And sometimes we were getting, I guess, some desk clearing exercises, you know, just let safe deposits deal with it. And of course, coming out of the last, I guess we're looking at 2 years now, gone's the 1 year coronavirus saga. I think we're approaching year 2. Coming out of that, businesses have had to change and they've had to evolve how they do their day-to-day practices. So we wanted to think about how we can support letting agents and landlords and tenants in this new normal that we find ourselves in. So for self-resolution, what we ask people is to just give us a brief explanation of how you've tried to resolve your dispute, why it's failed. We might ask you for a little bit of evidence so we can see where you're coming from, and we'll offer guidance. And the whole goal is to work between you guys as a sort of, it's a hybrid mediation, negotiation, conciliation, just as third party, to hear you both out, have a wee look at your evidence and give you the best advice, so you know whether it's better to pursue the adjudication, go for a settlement agreement, all this sort of stuff. The entire goal of self-res is to get you out of this 12-week process if we can help you avoid it. And it's hugely successful. When we first started this, leaving parties to their own devices, about 14% of cases were resolved at that point. We've increased the pool of, or the sample pool that we've been working with over the last few years. And since making it mandatory, about 53% of cases are now able to be amicably resolved without the need for formal proceedings. So that's great. So from an FTT's perspective, how would self-res sort of feed into any cases you were looking at? Should they do self-res before the FTT? Should they come straight to the FTT? What's your sort of take on it? Because I guess you can see it from both sides.
Yeah. Self-resolution is, if I can start off by saying how great self-resolution is as an approach to dealing with a deposit at the end of the tenancy, because you remain in control of that deposit. You know, you can use the Safe Deposits team to help you through the negotiation, but at the end of the day, the decision that you reach is your decision based on the information that they have. It's very speedy, and it's great to Paula used the word amicable there in terms of the relationship between the parties at the end, and that can be very important for people when they're closing down a tenancy, to make sure that everything is sweet at the end of the tenancy as far as is possible. So again, when you go to the First-tier Tribunal, you can present as part of your evidence the fact that you've been involved in self-resolution and that you've reached a mediated conclusion. I have to say that if you were looking at pursuing an extra amount over and above the deposit with the First-tier Tribunal, then you would have had to have reached the conclusion in self-resolution that the whole of the deposit was going either one way or the other. If you had a split agreement, then to be honest, there's not a lot of point taking the case to the first-tier tribunal at that point, because they will automatically say, well, why did you not settle the whole, this amount through the deposit? That was the obvious route to take.
So it's a sort of an all or nothing type stance with it.
Yeah, it's certainly evidence that you can put forward though. And it may go to another civil proceedings claim. I mean, that's the thing about the first-tier tribunal. As adjudicators at safe deposits, you're probably aware that we can't take into account counterclaims, but you may have a number of applications at first-tier tribunal which may actually involve those type of counterclaims. And then again, the conversations and the relationship that exists between the parties, like through self-resolution, may go to help establish some of those counterclaims.
Thank you. So as an adjudicator, as your FTT member, how do you approach your FTT cases as opposed to how you would approach the adjudication one when you're sitting down with evidence? Is it the same methodology you're working through? Can you be a little bit more renegade with the FTT? We know in adjudication you can't do any sort of investigation or go looking for evidence and all this sort of stuff. Does the FTT give you a wee bit more free rein to kind of push on questions and do a bit of digging around?
Yes, it does. It does, because the overriding objective of the tribunal is to make sure that the law is applied in a just fashion. So the overriding objective is to make sure that a case is concluded in that way. And in order to pursue justice in a judicial situation rather than in a alternative dispute resolution situation, then the tribunal can go and look for information and can ask for information and can make directions actually requiring information to be submitted. So for example, in a deposit case, they might make a direction asking for an inventory or a checkout report or any other information that they consider might be relevant. In a rent arrears case, they might make a direction asking for a rent statement and making sure that they understand exactly how the rent arrears have arisen. But of course, the main difference between the tribunal and adjudication is that you actually have the opportunity to put forward your case. And I say in person because in person really has changed between pre and post pandemic times, the definition of in person. It used to be that you could go along to the Glasgow Tribunal Centre and sit in front of the tribunal and actually put forward the points that you want to make. Now that's done either by telephone or video conferencing, but you still have the opportunity to actually discuss, put forward your points, question the other party if they're also appearing, and actually ask questions of the tribunal too. Okay,
so could you give us a brief run through as to how the process of lodging a claim with the FTT and the steps that you have to move through to get to this point?
It's very similar really to lodging a claim with safe deposits in terms of there's particular information that you need to make sure that you have provided. The tribunal has a massive set of rules, which I actually have here in front of me. It runs to several pages and there are more than
nice light reading.
rules. Nearly as many as the deposit regulations, but not quite.
Fairly chunky.
And they actually set down what you have to do to make an application. Okay. So, for example, if I look at Rule 103, which is about if someone has failed to protect a deposit at the end of a tenancy, which I'm sure is something that I don't have to flag as necessary to you guys. But for example, the application has to include the name and address of the tenant or former tenant, the name and address and profession of any representative of the tenant or former tenant, the name, address and registration of the landlord. Now, there are particular application forms which are available through the Housing and Property Chamber website, and it's always best to apply through those. Those applications are then sifted, and you would receive a letter saying whether or not the application has been accepted, at which point, depending on how the tribunal works, you may be invited to put forward your evidence at that point. You can make evidence submissions in a written manner or in person at a tribunal hearing or case management discussion.
I guess that's really good for a lot of landlords and agents, because I know with us, something that frustrates people is not being able to explain themselves verbally, because adjudication's completely documentary, and it has its limitations. There's nothing more sort of upsetting when you see that someone's lost a case based on, I guess, a technicality. Whereas if we were able to just kind of push and ask a few questions, the outcome may have been different. We have our limitations. You sort of answered this, but one of the questions that came up was what makes a good FTT submission? As I guess similar to us, it's detail, the information that you've got.
Yeah, to be honest, if you're talking about a claim on a deposit at the end of a tenancy, it's very similar to the evidence that we would be seeking, Paula, in terms of, make sure you have to provide a tenancy agreement. It's helpful to provide an inventory and a checkout report, any invoices that you have, an explanation of how issues have arisen, steps that you've taken to try and resolve them, and those kind of things. I suppose probably the First-tier Tribunal would not accept video evidence, and as an adjudicator, I'm not a big fan of video evidence anyway. But yeah, it's very similar kind of level of evidence. And for rent arrears cases, rent statements are required, etc. The burden of proof is still on the person making the claim, whichever way you go, whether it's adjudication, and whether a tribunal or an adjudicator will all make a decision on the balance of probabilities.
So if you were a landlord looking to submit a claim against a tenant that basically there's a lot going on at that property, FTT is where you're going, what do you need from the responding party to go ahead? Do they need to be present? Do they need to respond to anything, or is it sufficient just for you to state your case?
That's a good question. You don't need the respondent to be present. It's really a matter for them how much they engage with the tribunal. The tribunal will make a decision on the evidence before them. So if the respondent doesn't put forward any evidence and doesn't actually appear before the tribunal, either by telephone or video, etc., then the tribunal will make a decision on the evidence before them.
Okay, so that's all the pre-questions, I guess, that have been sent. I keep saying I guess today, I don't know what's going on with me. That's all the questions I know, it's all the questions that have been sent ahead of time and from the team. If you've got anything you want to pose, we can open up the floor to everyone. You can pop it in the wee chat box below. But that was really helpful for me, especially Sarah, in our capacity as the adjudication team here. We see a lot of worries coming through from people. Is this going to affect my case at the FTT? Should I do adjudication? And the counterclaims that you touched on, we can move a lot of those out of adjudication to the First-tier Tribunal. It's for us, when a tenant says, I didn't pay my rent because, we know straight away there's really nothing we can do. We can do in that instance very little. Whereas in the FTT, can you do a wee bit more? Can you do anything with that, I guess, where if a tenant says, I didn't pay my rent, and you can ask why they've not done that and take that into consideration, whereas with us it's just an open and closed case.
The cases are separate decisions, Paula, but what happens is cases at the tribunal are conjoined. So you may have several cases on the same property about the same tenancy. So you may have a case where, the landlord's claiming for the deposit at the end of the tenancy, but the tenant puts in a claim because the deposit has only been protected at the last minute. They also put in a claim about the for damage because of the state of repair of the property, a civil proceedings claim, and they also might make a claim against the repairing standard. To say that the property isn't in a sufficient state of repair, it's not watertight, it's not windtight, etc., etc. So you can actually have a number of claims against one tenancy, and increasingly we're seeing that because we've seen such an increase in rent arrears cases at the First-tier Tribunal, because the amounts of rent arrears, as you'll all be aware, are well in excess of deposits in many cases now.
I was going to say that actually. We thought we would see a lot more rent arrears cases than we actually have. We saw a brief flurry of them during the summer last year. There was this belief amongst tenants that, there's a stay-at-home order in place. That means for the students, that means goes back to mum and dad's house. So I'm just going to walk out of my property and I'm absolved of all responsibility. And I think there was also a bit of confusion with tenants between the eviction ban that came into place that didn't automatically mean you were absolved of rent obligations. So we did see a flurry of that. I mean, I assume we're probably going to see it again coming around next summer when the restrictions are lifted in their entirety. But it's interesting that you guys you're seeing this too, that tenants are still just leaving.
Yeah, that's right. Yeah, I think I was just having a look at the annual report of the tribunal last night, actually, because the figures have just come out for 2020, 2021. And I think there are about 2,500 applications received at the Housing and Property Chamber. And the greatest number was rent arrears cases. 80% of the claims involved private rented sector applications, but the actual number of eviction applications halved compared to the previous year because of the change in the notice period and the effective stay on eviction.
That was actually one of the questions I was going to ask, was about the volume that you guys turn over annually, the amount of cases you see, because in adjudication, the dispute rate across the scheme is 0.7%. So the likelihood of you actually ever getting into adjudication is less than 1%. But, you know, the bigger your portfolio is, the more likely it is you're going to find yourself here. And I think when we did our figures at the end of the financial year, we had about 4,500 cases come through adjudication. So it was interesting to see how many you're actually working through at the FTT as well. So I've had a couple of questions here. So Carolyn asks, a lot of people query how to actually act on the decision of a tribunal if for financial compensation, whether damage or rent arrears. Can you provide advice?
Well, I can't actually provide advice as a tribunal member. It would be wrong for me to provide advice. So actually, to act on the decision of a tribunal for financial compensation, you can go back to the tribunal and seek further advice and payment orders. The tribunal can make time to pay orders, etc. So if that's what you mean, Carolyn, then there are kind of further civil proceedings that you can take forward.
Okay. Anne has asked, if an appeal is put in regarding a decision is submitted, what is the process, and is this reviewed by the same person who made the decision?
Well, that's quite an interesting one there, Anne, to be honest, because it's obviously different with adjudication and the First-tier Tribunal. So as an adjudicator, if there's an appeal, a review request about my decision, then it's appealed by it's reviewed by a second adjudicator who's not the same person. A fresh pair of eyes looks at the case again and makes a decision accordingly. When you agree to go to adjudication, and I think this is right, Paula, then you're basically accepting the decision
it's
by the first or the second adjudicator.
Yep. There is an end point. Yep.
Yeah. At the tribunal, it's completely different, obviously. If a decision is made by the tribunal, then the upper tribunal exists to deal with those appeals. And the upper tribunal for the Housing and Property Chamber consists of 8 sheriffs. And it will be one of those sheriffs who makes a decision. And then there's a further appeal route from the upper tribunal to the Court of Session in Edinburgh, and from the Court of Session to the Supreme Court. So there's, you can go on and on from the Housing and Property Chamber.
Become a massive time sink for you.
Yeah, a massive bill. But if you were minded in that direction, then it's because the Housing and Property Chamber sits in the judicial system, which is obviously completely separate to the way that Safe Deposits is dealing with things, then the opportunity for appeal is much greater.
Okay. You touched on something there about a massive bill at the end of it. Your initial application to the First-tier Tribunal, is that free to use?
Yeah, absolutely. And indeed, if you were to go all the way to the Court of Session, then as a party litigant, someone who is not represented, so as a landlord or a tenant, then you could carry on just representing yourself all the way through. Yeah. As a letting agent, then you might want to seek legal advice, and then of course, you've got legal fees. You've potentially got to deal with the costs of the other side as well, because even the Housing and Property Chamber, although it's free at supply, we can make awards of costs against one party or another. Okay. Although it's very, very rare to do so.
Yeah. You've sort of led into a question that we have here from Neil. He's asking what proportion of landlords and tenants represent themselves at the FTT rather than instructing a solicitor or letting agent to act on their behalf?
Yeah, I haven't got any official figures, to be quite honest, but I would say that the majority of landlords and tenants represent themselves. There are some that are more professional landlords instruct a solicitor or letting agent, but very rarely do I see either a solicitor or letting agent in the cases that I deal with. I would say that I mainly see landlords or tenants, and in factoring cases in particular, which is slightly different to what we're talking about, then it is mainly homeowners who represent themselves.
Yeah. The adjudication, excuse me, the first-tier tribunal process, it can look a little bit daunting, like you were shown as a list of rules that you had there. Something we get asked quite a lot is, if you're sending me to the first-tier tribunal, what should I be doing? Who can I speak to? What rule do I apply under? And obviously we have to tell you, it's not for us to decide which rule. What help's available for people to make sure they're not getting thrown out at SIFT stage, for example, if they've lodged their case under the wrong rule or they're missing something? Is there a helpline or are there people they can reach out to?
Oh yeah, there's a big team at the First-tier Tribunal that can help with any queries that you have. And I have to say, just as the team at SafeDeposits is absolutely fantastic and absolutely top class, then the First-tier Tribunal also is fantastic. Although I have to say that SafeDeposits probably beats them in the speed that you answer the phone. You may have to hang on a bit more at the First-tier Tribunal.
I'm sure our figure last week was 8 seconds. I'm just going to drop that in there.
So I don't think it's quite as good down at the Tribunal Centre, but they are very, very helpful, and they will do everything they can to guide you. There's also a lot of information available on their website. And I think the applications are available on the website. And although it looks a bit daunting, to be honest, once you get into the system, it's very similar to SafeDeposits system, in as much as, we have particular time limits in which you have to do things at SafeDeposits. So does the First-tier Tribunal. And as long as you stick to the advice and stay on top of the application, then it's really not as daunting as all that.
Oh, that's really
one of the tribunal rules is to try and make proceedings as informal and easy for parties as possible.
And it's a huge help. It's a huge help. I know adjudication terrified a lot of people, that it was this, we call it the quasi-judicial process. I think that's one of Alison McDougall's common phrases that she likes to use. People who don't go through this a lot, particularly landlords, agents, you might see this 2 or 3 times a month. Landlords, it might be every 1 to 3 years, depending on the length of their tenancy. They're a bit worried that adjudications, they're going to get out of their depth pretty quickly, and actually it's not really the case. So it's nice to hear that the First-tier Tribunal is very similar in that regard. That'll be good. I have been down to the FTT myself, down, is it York Street you guys are on? Yeah, down there.
Yeah, Glasgow Tribunal Centre.
Yeah, Glasgow Centre. They were lovely. Everyone was so nice. It was a nice place to go. And I know back in days gone by, you were able to sort of sit in on some hearings. I hope that can be reintroduced at some point, because that was good we had a few law graduates come in here, and it was nice for them to get a bit of an understanding, and some of the adjudication team spent some time down there too to get a grasp of the differences and the nuances between. So I hope we can get back to that at some point.
Yeah, so do I. Although interestingly, the number of cases where representatives actually appear has increased.
Oh, really?
They just pick up the telephone rather than actually having to go down to the Tribunal Centre. So
it's less effort.
Yeah, exactly. You can do it from your front room now.
Yeah, very good. I love that we've all moved to this sort of online way of working now. It's so much easier. Okay, so I mean, the questions have all dried up here. There's no one else has come through, so I won't take up much more of your time, Sarah. What I will say to everyone is, contact us if you've got any questions. You can send them to our info@ email address. That's info@safedepositsscotland.com. We'll collate them there and I'll send them over to Sarah, and towards the end of the week we'll get them sent out to everyone if anything more comes in. And other than that, thank you for your time today, Sarah. I found that really helpful. I'm sure you guys here will have taken something from that. And we'll be doing another session in a few weeks' time. I think around November, we're going to talk about purely adjudication and a day in the life of the adjudicator and how you approach cases, and we'll do it from the other side. We'll be advertising that on our websites, our socials, all the usual places. So we will be back. So get your questions ready for that one. But at that, I will close off the session and let you all carry on with your days. And again, thank you, Sarah, for giving up your morning.
Thanks for attending. Nice to see everyone. Bye.
Bye.